So we'll give everyone a moment to finish getting signed in, and then we'll begin the webinar.
That's right. No, it just, no, just somehow when you speak standing up.
Director of the AIA New Orleans. Thank you for joining us today for our webinar on labor, employment, and COVID-19. This is the third in a series of webinars that we're holding about issues that have come up around the AEC industry with the breakout of the coronavirus pandemic. Today's topic will focus on labor and employment issues that have arisen in this rapidly changing work landscape, and it is especially geared towards firm owners and managers. A note up top about the format for this webinar: all attendees will be muted, but you will be able to ask questions by typing into the Q&A function, so be sure to type out all of your questions there, and we will answer them at the end of the webinar. We'll be making a recording of this webinar available afterwards. So if you have any questions about the slides or need to see something again, you'll be able to find it there in the recording. And finally, if you run into issues with connectivity, unfortunately, we are a two-person team and can't really handle IT while we're conducting the webinar, but you will have a call-in number available as a good backup for you. On the agenda for today, we'll be hearing from LSB Murov and Ted Leclerc on labor, employment, and COVID-19. Both are employed by Deutsche Kerrigan. At the end of the presentation, we'll have a small Q&A session, and then we'll close out with some upcoming education events and other ways to stay connected with the AIA. So we'll hear from two speakers. LSB Murov, and correct me if I'm pronouncing your name wrong.
That's actually fine. I can tell you that if I spell my name M-U-R-E-A-U-X, everyone could say Muro. Trouble. 1 second, please. Hold on. And no one seemed to be able to say Murov, and it's okay because technically I'm mispronounced my own name. It should be Murov. We said we're doing fine.
Great, great. So Ellis devotes his practice to advising clients and litigating in the areas of commercial litigation, restrictive covenants, intellectual property, and labor and employment law. He is admitted to practice before all state and federal courts in Louisiana, the 4th, 5th, and 9th Circuit Court of Appeals, and the U.S. Supreme Court. He also has an administrative law practice before the National Labor Relations Board, Equal Employment Opportunity Commission, and Department of Labor, Wage, and Hour Division. He served as an adjunct professor of labor law at Loyola University School of Law. He has experience in alternative dispute resolution as an arbitrator and mediator. He has also served as chairman for the firm's 401k and profit sharing plan committee since 2004. And our other panelist today is Ted Leclerc. He represents clients faced with labor and employment law, professional liability defense, civil rights litigation, and constitutional law claims. His experience includes developing a national coordinating counsel program for a Fortune 200 national retailer. He currently serves as that client's national coordinating counsel for high-value personal injury claims. He's a frequent speaker for a variety of professional groups in his practice areas and also provides training to companies on personnel issues. So now we will hand the presentation over to our panelists.
Thank you so much, Lauren and Aaron. This is Ted. I might just give you, and with a last name like mine and Ellis's explanation of his, you can understand why
Yes.
I only lead my life as Ted. and so I'm going to give you just a few more details about my friend Ellis, and he may tell you one or two more things about me, because it's nice to know the people with whom you deal. My friend Ellis has been practicing for nearly 40 years. He's tried numerous cases to verdict in state and federal court. He's won numerous cases on motions for summary judgment in state and federal court. He's a frequent public speaker, and his authorship includes books on employment law. He has an active administrative practice, as you heard, including at the EEOC, the first stop for most discrimination claims. He's active in the ABA, including being the former chair of an employment law subcommittee. He's been honored in chambers for over 10 years. He's a super lawyer. He's a best lawyer. Those are some of the honors as well. He's been married to Beth for 20 years, and they have 2 stepdaughters. I sure am pleased to be here today with my good friend and colleague, Ellis.
Thank you, Ted. Let me add a little bit about Ted, with whom I've known 17 years since he came to practice with us at Deutsch Kerrigan, although Ted's been practicing law itself for a little over 30 years. At Deutsch, he's currently the head of our commercial litigation department, which includes labor and employment, and also includes professional liability, but not construction. Kelly and Keith Bergeron and others who y'all may know are in that section. Ted does all kinds of litigation, whether it's commercial, employment, or professional liability. Ted's won a number of cases at trial and on summary judgment, including in January. Ted tried and got a verdict, I believe, from Judge Vance in a ADA sex discrimination and retaliation case. Ted's a lot more active in the community than I am, and he should be commended for that. Among other things, he's led an effort to replant trees along St. Charles Avenue, to realign St. Charles Avenue as a historic landmark. I could go on. Ted's been married. I mean, there's more, but y'all want to hear some other things, I suspect. Ted's been married to Courtney and has 3 kids. I think they've been married for like 27 years or so.
That's right.
You know, I hope we can answer. I hope we can provide y'all with some interesting information, answering your questions. Ted, you want to take it from here?
Thank you, Ellis. Lauren, the next slide. Deutsch Kerrigan is our law firm. We were founded in 1926. We have 69 lawyers, and our practice is Louisiana and Mississippi. I'm licensed in both states. We have 25 specific practice areas. We cover every facet of litigation. Our lawyers are frequently recognized with honors such as best lawyers, super lawyers, and chambers. We have the preeminent construction law defense team in the state. And that's really how Ellis and I, as employment and business lawyers, come to you. Next slide, please. You may know us through the leader of the construction law group, Kelly Thayard. Kelly Thayard runs that preeminent group. You've seen her quoted in the Times-Picayune with the largest construction case in the entire region. Kelly is also now DK's managing partner. Next slide, please. And I'm sorry for having to ask for the next slide over the phone. You'll want to know that Ellis and I are maintaining proper social distance in a conference room at our law firm. And instead of having to look at us, we're letting you look at the PowerPoint we created. But because we're doing this remotely through the miracle of technology, I'll have to ask for each slide to be advanced. So that's why you'll hear it. We're here today, Ellis and I, to talk about employment and business-related issues and COVID-19 and the coronavirus. We look forward to taking your questions in the Q&A session at the end, and even during the session is possible as well. Next slide, please. That angry red virus you see there is attacking us. It's causing us personal and financial loss across Louisiana and across the country. Next slide, please. We're not here to talk about this kind of corona. Although for fans of it, like myself, you'll want to know that production was stopped in Mexico as they declared that the product was, quote, non-essential, close quote. A result, I submit to you, would not likely be reached were it produced in New Orleans. Next slide, please. Dr. Fauci has guided us with plain talk every day. The virus has its own timetable. Next slide, please. And in New York and New Orleans, we have both succeeded in flattening the curve, something none of us except someone called an epidemiologist has heard of before. Next slide, please. That flattening of the curve that Dr. Fauci has talked about and that our governor and mayor have talked about has come at a great cost. With over 582 people perished so far, cases in every parish in Louisiana, over 17,000 cases in Louisiana, including Morris Bart yesterday and Sean Payton earlier. To stop it, the governor had to take and the mayor had to take dramatic measures, closing schools, most businesses, canceling non-elective procedures to free capacity at our hotels to treat at our hospitals, to treat COVID-19 patients. Next slide, please. Nationally, there have been over 400,000 cases and there have been stay-at-home orders in virtually every state. Next slide, please. The cost to Louisiana and the country have been immense. Lives have been lost. The economy, once at a record pace, has been shut down. Next slide, please. The government has responded, and we've had multiple very lengthy pieces of legislation passed. The paper this morning, if you read the Picayune today, reflects that another COVID relief bill is under consideration with $250 billion targeted for small business, although there's division as to whether the legislative bodies will pass it. So after the talk today, stay tuned for what may be coming close on the heels of what we've already got. Let's look at a few key features of these two pieces of relief legislation. First, we'll take a look at the Families First Coronavirus Response Act, which I'll refer to as the Families First Act. And then we'll also take a look at the Coronavirus Aid, Relief, and Economic Security Act, or what we'll call the CARES Act. Both of these pieces of legislation are very lengthy, and both of them have been subject to recent interpretation from different branches of the federal government, including the Department of Labor, the EEOC, and other branches. Next slide, please. First, let's take a look at the Families First Coronavirus Act. It was passed on March 18, 2020 and signed. The Department of Labor has completed the initial regulations to go with it and to implement it. Next slide, please. Who's covered under the Families First Act? It covers small businesses, sole proprietors, contractors. It creates the first ever federal mandate that employers with fewer than 500 employees provide short-term paid sick leave and long-term paid leave to deal with illness or care for an affected a loved one. And it takes effect April 1st. So it just has taken effect. Next slide, please. So there's FMLA leave, which we'll talk about later, the Family and Medical Leave Act, which has gotten these amendments from the Families First Act. But FMLA leave did not apply to businesses with fewer than 50 employees. This new act does. And its provisions are as follows. If you have 500 or fewer employees, the employee can take up to 2 weeks paid sick leave at full pay up to a cap of $511 per day if they're directly affected by COVID-19. And they get to take partial pay if they must care for an affected family member. One qualifying reason to get the sick paid leave is that they can't work because of quarantine orders or the COVID-19 symptoms, and they're seeking a diagnosis. So this leave provision would have direct effect to Louisiana, where everybody is under a stay-at-home order and quarantine. The law amends the Family and Medical Leave Act to provide workers with 10 weeks off at a partial pay to care for children whose school has closed or whose child care center is closed due to COVID-19. So that applies to everybody in New Orleans because all of our schools and all of our child care centers are closed. The first 2 weeks of this new leave are unpaid, and then the 10 weeks after that are partially paid. The good news for employers, and this is significant, is that covered employers can seek reimbursement of any qualifying leave through tax credits. So let me repeat that because you all are employers out there. If you give this new leave, which is mandated, this new expense, then you can get money back for giving that leave in the form of tax credits. So the employer bears the initial expense of how the paid sick leave and the paid FMLA leave, and then gets a dollar for dollar reimbursement from the IRS. There was also concern from businesses over cash flow issues created by this paid leave. To address that cash flow concern, employers can request in advance of anticipated tax credits and refunds. Next slide, please. Oh, go back, please, one. Sorry. Before we get to the CARE Act, let me finish up with the Families First Act. And as we'll discuss later, the FMLA gives workers job-protected unpaid leave for up to 12 weeks in a year if the worker has a serious health condition or if they need to care for a family member with a serious health condition. So the Families First Act makes some important changes with respect to that existing legislation, the FMLA, and my colleague Ellis will talk about reconciling those provisions a little bit later in our presentation. But it is a complicated issue for employers, and they'll need to pay very careful attention how to reconcile these two different acts and provide the appropriate leave. Next slide, please. One final word about the Families First Act, and it may apply to some of you all out there. I said earlier that it applies to businesses with fewer than 500 employees. There's a very limited exception for businesses with fewer than 50 employees. And it says that those businesses can seek to avoid paying the leave to workers whose kids' schools are closed and the child care providers are closed to the extent that the workers' absences would create a severe financial harm to the company's operations. They're still working on the different interpretations of this limited exemption, but this is a trap for the unwary if you decide not to pay under the Act, because there will be a lot of scrutiny later for people who seek to avoid paying leave under this exemption. And it's one of those things where the guidance is evolving even as we speak. And so it carries a fair amount of risk to not pay. And so you would want to do that after very carefully looking at the regulations and visiting with somebody about what the restrictions are on this limited exception to the Families First Act. All right, the CARE Act, or the CARES Act. The CARES Act has a couple of very important provisions to it, and my guess is that many of you have already taken a close look at this act. In fact, many of you may have already filed for the forgivable loan under the act, and we're going to talk about that as well. Next slide, please. So the CARES Act Paycheck Protection Program has $349 billion in funding. It's a first come, first served in application, so it's possible that the funding could run out. It covers businesses with 500 or fewer employees, with a few exceptions. The casinos are left out, private clubs are left out. It covers independent contractors and self-employeds. There is one notable eligibility exception, and that would be for small businesses who take a small business loan. Those businesses are not eligible for the forgivable loan under the Paycheck Protection Program. That's recent guidance from the Department of Labor over the last several days. But the basic features of the loan would be that it's a forgivable loan with the amount at 2.5% of the average monthly payroll. And there are a variety of very specific rules as to how you calculate the average monthly payroll. And the regulations have also said, they've gone back and forth, but most recently they've said that it looks at the 2019 payroll with a max loan of $10 million. April 3rd would be the first application date, which is already passed, and that's for small businesses and sole proprietorships. And April 10th is the date for today for independent contractors and self-employeds. There's a cap on the amount that you can claim under each employee with salaries up to $100,000. And the loan payments are deferred. So it carries an interest rate if the loan is not forgiven or repaid, but the loan payments are deferred, which has got the attention of employers all across New Orleans, Louisiana, and indeed the entire nation. Next slide, please. There's the funding, and there are the dates when the applications can go out. I suspect that many of you have already applied. The banks are overwhelmed by the volume of loan applications, and different banks are treating the loans in different fashions. So there'll be variation between banks such as Iberia and some of the others. So you'll want to talk to your financial advisor or your CPA to find out which place is best for you to do your application. Next slide, please. Before we get to the labor and employment statutes, which my friend Ellis is going to cover in greater detail, a few words about the Payroll Protection Act and what kinds of expenses it covers. So the average monthly payroll includes payroll costs, which are salaries, wages, paid leave, state and local taxes, group healthcare costs, retirement costs. It also includes rent, utilities, and interest on mortgages. So all those different elements can go into your calculation for the average monthly payroll. In terms of the conditions you as the employer have to maintain in order to receive loan forgiveness, which is the name of the game, you have to maintain the same number of employees and the payments are deferred for 6 months or even up to a year. The act effectively incentivizes us as employers to keep our employees. The loan forgiveness is therefore reduced in proportion to the number of employees that are dismissed from the workforce who receives the loan. However, if the company has already terminated employees, the company can still get the full amount of the loan forgiveness if those employees are rehired by June 30, 2020. A couple other provisions of the CARES Act. It adds $600 a week over and above state benefits to unemployment claims. So if people have been laid off earlier, there's a new unemployment benefit out there directly from the federal government. And it adds these additional weeks above state unemployment benefits to a max of 39 weeks. Also, if the state has short-term compensation funding, which means an employee who's put on reduced hours, the feds will provide support for 50% of the cost of that program, such that an employee put on reduced hours can get partial unemployment benefits. The Act also provides for unemployment assistance for self-employed workers, independent contractors, and others who traditionally did not get unemployment. It also provides for payment to individuals. That's what you've heard about, the direct payment, which is $1,200 each or $2,400 for joint filers. However, the payments phase out for single filers at $98,000 and for joint filers at $198,000. Therefore, if you file jointly and your earnings are over $198,000, you won't be getting a direct payment. That's the conclusion of that act, and now I'll turn it over to my partner to talk some more about the labor and employment law statutes. The next slide, please.
Thank you, Ted. Good afternoon. I want to just briefly go through some of these laws just to make sure everyone knows what we're talking about. In many cases, you will. So the Age Discrimination Employment Act prohibits discrimination against those over 40. The Americans with Disabilities Act protects people from discrimination based on a disability. And I will tell you one that's probably going to shock you right now, but the Department of Labor, EEOC, have not yet come to the conclusion that the coronavirus constitutes a disability. Just telling you, I'm not telling you I agree or disagree with it, but believe it or not, here we are. The Civil Rights Act of 1866 it's viewed as a race discrimination statute, also of national origin. Basically just covers, you have the right to make a contract just as a white person would, and they converted that into an employment discrimination statute. The Civil Rights Act of 1964, I believe most of y'all know, prohibits discrimination on the basis of race, sex, color, religion, and national origin. USERRA is a long acronym for you can't discriminate against someone who's a veteran or serving in the armed forces. And whistleblower laws are a little complicated, but basically, bottom line is if you say something or you think someone's violating the law and you report to someone who's an appropriate recipient, they protect you against retaliation or discrimination as a result of that. Next slide, please. So just because I'm not sure, y'all, I have to apologize to you, I'm not exactly sure with whom I'm talking, other than y'all are members of the AIA. I don't know how many employees your companies or you have, but this slide shows you to be subject to these laws, you either have to have 15 or 20 employees, unless otherwise indicated. Section 921, no. Next slide, please. So, believe it or not, when we talk about ERISA here, it doesn't seem to come into play except that under either the CARES Act or the Family, probably the CARES Act, employees can take loans and pay them back. They don't have to, they have longer to, before they have to take required minimum distributions. And we can answer any questions, but that's why they're here. The National Labor Relations Act, most people believe concerns unions, and they do, but actually it applies to employers irrespective of whether there's a union or not. The point being, employees can band together, and they call this protected concerted activity, address any term or condition of employment, address wages, and it does not have to be a union. Next slide, please. So, you don't think of the ADA as a leave statute, but believe it or not, it is, because leave can be, so part of the ADA requires employers to reasonably accommodate those with a disability. And believe it or not, leave can be a reasonable accommodation. We'll get into more about that, but that's why it's there. FMLA is actually a leave statute. It's Family Medical Leave Act. And we're going to get into some of the different in the FMLA and how it operates interactively, or in the relationship between the FMLA and the ADA and the new acts. HIPAA, you don't think really goes here. And it's not exactly a leave statute, but the FMLA has some privacy components to it. HIPAA clearly has a privacy component, and we're going to talk about how employers have to have a little bit of a tightrope to walk in complying with HIPAA and dealing with, say, people who have the coronavirus or may have the coronavirus. And workers' compensation, again, you wonder why it belongs here, but in fact, you can get leave if you can't work because of an on-the-job injury. You can be off work and be paid a statute. We'll deal a little bit more with sort of the curiosities of that one. Let's go to the next slide, please. ERISA, because you take out money to put in a 401k plan, it goes there. Fair Labor Standards Act, you don't think it's being applicable here because people may be working less, so you're probably not going to deal with overtime, but you will maybe have to deal with minimum wage. Otherwise, if anyone has any Fair Labor Standards Act questions, we can deal with that. The Louisiana Revised Statute 23631 is simply you have to, let's say you're going to have layoffs or someone quits, you got to pay within all monies due that employee within at most 15 days. Unemployment compensation, Ted's already talked about, because there are supplements. Next statute, please. Now, I'm trying to go fast, but we don't have that much time. This one's going to take, I'm trying to go a little slower here because there are some unusual, excuse me one second, issues here. So, when you're dealing with the FMLA, normally you have to have 50 or more employees or it doesn't apply. By the way, if you don't have 50 or more employees, the FMLA does not apply. But under the Families First Act, rather than having to have work for a year and at least 1,250 hours during that year, it's only, I believe the answer is you have to work 30 days. In the FMLA, you can force someone on FMLA leave to, by the way, that covers serious health conditions, and Corona, no one's going to question that. But you can make them take vacation, not under the Families First Act. There's a real complicated one here, and Ted and I have actually been talking about kind of getting our arms completely around this, but there's the emergency, whatever it's called, we covered it earlier, the Emergency Relief Act that says the way we read it, and we're not telling you that we're 100% confident, but we think we're reading it right, you're not required to give this emergency leave under FMLA or FFRCA, but if you have a sick pay policy, sick pay bank, whatever you want, money you can give an employee for sick pay, then you can be required to give up to 2 weeks of paid leave up to a certain amount of money. Ted and I can address that later. So let's go to now the interrelationship between the FMLA and the ADA. At first glance, they're not the same because the FMLA covers serious health conditions, which doesn't necessarily have to be a disability. The ADA covers disability, but under the ADA, you can get leave as a reasonable accommodation, unless it's unreasonable or an undue hardship. Those, I hate to say are terms of art, but they come up if you practice in this area of law where Ted and I practice, or you may have come across it. What's crazy here, and they're kind of doing it on the run, and so we need to be, what's the word, a little tolerant and sympathetic to our elected officials who are doing their best on the run. Usually you would ask a doctor, tell me how long they're going to be off work, what's the diagnosis, prognosis, when can they return, because you don't have to give indefinite leave. The problem here is, and you're used to asking the employee, give me, have a doctor's note, have the doctor send us so we can decide whether this leave is warranted. Well, you don't actually have to do that under the FFRCA and the CARES Act. They're being sympathetic to the doctors who are overwhelmed. All they have to tell you is, here's the doctor's name, address, phone number, and they said I needed to quarantine. Something along those lines. Let's talk a little more about the interaction between the ADA and the FMLA, because and we're just living in a brave, new, different world. The EEOC has come out with a update on their pandemics as they apply in the employment complex. I mean, they did it last year before this. Amazing. But so you can take someone's temperature before you let them come into work. By the way, whether you want to do that or not is a real interesting question, because I've got employers who say, I don't want to know that. Then I have to tell people. Then I can't tell people. That's HIPAA, and we'll get to that. But if you're going to have someone take temperature, by the way, this may be coming. It's kind of an answer to one of the questions y'all kind of sent in from the audience. But you better have a qualified person doing it, trained and all kind of sanitary measures, etc. By the way, unlike, let's say other laws, if someone tests positive, they have a fever, you're concerned, you can ban them from the workplace. That's something that you would normally have seen in, let's say, the ADA. For those of you who can remember, and it's okay if you don't, remember there was, not that AIDS no longer exists, but there was an AIDS epidemic, like the 90s, something like that, Ted? Somewhere in there. But and people didn't want AIDS people coming into the workplace. They made you, unless you're a hospital, you couldn't ban an employee with AIDS from working. You can ban an employee with coronavirus from working. FMLA and HIPAA, these are kind of simple in a way until, like everything else in the area of law, it isn't so simple. The issue is privacy. So if someone tests positive, if someone has the virus, you're not supposed to tell other people. That's HIPAA. But you can tell public officials. You can inform the public. What do you tell your co-employees? Their co-employees, excuse me? That's a great question, and that's why some employers don't want to even test at all, and then they don't have to worry about what they say or don't say to their other employees. it seems to me that the answer, and by the way, they're doing this is other stuff that's kind of been done on the ride. Folks, we had someone here who may be positive. We want to make sure, blah, 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 and don't say the name, but take steps to protect the current employee. So let's look at the Families First Act, HIPAA, and the National Labor Relations Act. Again, these things don't seem to be related, except that if employees are concerned about John Doe, they can talk with each other and even go demand something of you and not be fired for doing it. Which makes it, this doesn't make your job a whole lot easier, but I got to tell you, it's out there. They can refuse to work. They call that strikes in some places. As a concerned activity, what do they want? And I'm not telling you to let them strike, but hey, kind of want all this together. We don't want to make our employees sick. That doesn't help your productivity at all if they can't work. We deal with it. So now let's talk about some of the things that, like, what is workers' compensation doing here? Well, okay, it covers on-the-job injuries. So who's to say if someone contracted the coronavirus on the job? It's a lot easier if you don't have to do it yourself and you have a workers' compensation carrier, like there must be dozens of companies that write this. Liberty Mutual, I know, writes, and I used to work there before I went to law school. But, you know, how can you say they caught it at the workplace? By the way, how can you say they caught it at the workplace when they're working at home? You don't know right off the bat, and have to ask a lot of questions. You can ask questions, you know, look, this is not our job to litigate the case here, but think of some simple questions like, anyone else in your household have it? Anyone else in the workplace have it? By the way, the answer might be yes, and they're asymptomatic. This thing is a little, we're in a brave new world until we get our arms totally around this. Negligent hiring and retention. Where does that come to this? Because under workers' compensation, the sole remedy of the employee is to sue the employer. The employee cannot sue the employer for negligence, such as negligent hiring and retention of, now let's fill in the rest of the blanks here, someone who's got the coronavirus. So if someone with the coronavirus who works for you gives that virus, assuming you can be proved, to a non-employee, the non-employee, other company, whatever, can sue you. I mean, you know, I hate to be the guy bearing bad news, but at least let me make you aware of this problem of why you need to know who you're hiring. Now, the cases are, they've never had a coronavirus case. So, you know, I'll just share with you the leading case, and you see where it goes. But Orkin at one time decides they're going to hire someone to do their spraying of various houses and businesses. And they hire a guy who served time in jail for rape. Guy goes and, you know, sprays a housewife's home, comes back that night, having seen the home, how to get in, and I won't fill in the rest, but you can imagine it. The key here is, do you know someone's got it? By the way, what steps you take to know someone's got it, and it's just a nightmare. I don't want to cover this anymore other than let me at least get you aware of this so you're thinking about it. If we can, do we want to go to the, how about you take business interruption, then we'll do the questions at the end. How's that?
That sounds great. Ellis, thank you. Before we go to the next slide, just a couple of quick follow-up points with the good information that Ellis just gave you. Remember, we talked earlier about the Department of Labor regulations for these acts. The acts come out so quickly, they don't come out fully formed. And so the different governmental agencies have to give interpretations for what they mean. So Ellis and I were talking about a couple of the really interesting ones earlier from the Department of Labor. For instance, Do employees now get 28 weeks of leave a year between the FMLA and the Families First Act? The answer, no. They only get one 12-week set of leave, but some of it now may be compensated instead of uncompensated. Next, does an employee get leave if they're doing telework? Well, here's a lawyer answer, it depends. What it depends on is if the employee can do their full job via telework, then no leave. But if they can only do a partial job, then they would be eligible for partial leave. And then the third interesting one is there leave available if a business closes? And the answer is no. The answer for the employee is then to seek unemployment if the business is closed at that time, which is perplexing for some employees because they think they have this leave, but it's not there unless the business is open. And finally, as we conclude the first part of this, or the second part of this program, I would point out that the CARES Act has a provision that says employers cannot discriminate against employees who take leave or who file a complaint for enforcement under the Act as it relates to leave. And with that, we'll switch. The next slide, please. The final part of our presentation deals with different types of insurance coverage which could be implicated for you, the business owner. And there are two in particular that will be interesting: the business interruption potential coverage and the EPL coverage, employment practices, if you're a business of a sufficient size to be covered under the statutes that Ellis explained so well. The next slide, please. Business interruption insurance. Read your policy, right? That's what you've got to do, unfortunately. And most policies will require that the premises suffer some sort of, quote, physical damage, physical loss, unquote. Many of us remember a version of this issue from the Katrina days of 2005. If windows were blown out or elevator hatches blown off or parts of the roof were damaged, you had, quote, physical damage, close quote, and that altered your property and probably triggered an ability to collect business interruption insurance. Next slide, please. You need some sort of physical loss in the way that most policies are worded. Not all policies, so you have to read your policy or talk to your insurance broker. But traditionally, you need some sort of physical loss. Next slide, please. We have two different types of interpretation across the country of physical loss. Some of it even coming out of Louisiana. The narrow view, which is not going to be favorable for the creative seeking of business interruption insurance from the COVID-19 event, is taken in three different cases, which I'll highlight for you. The 8th Circuit in Minnesota in the Source Food Tech case said a ban on importing the insured's beef was not a physical loss as the beef inventory was not physically harmed. In New York, when the power was shut off before Sandy, that was not a physical loss. In Florida, it was not a physical loss unless the property had physical damage and needs repair. Next slide. However, our friends in New Jersey take the sweeping wide view of physical loss and look for this to be advocated in different places around the country as it relates to COVID-19. In New Jersey State Court, it is a physical loss if the property is, quote, temporarily unfit. In another New Jersey case, a release of ammonia inside a plant created a physical loss. Next slide, please. Civil authority will have a place in your policies because you could be shut down on the order of a government, which we have been. from the governor and from the mayor. Unfortunately, the civil authority shutdown for business interruption also requires a physical loss. Next slide. And after the SARS epidemic in early 2000, most insurance companies, but not all, put in a provision which excluded coverage for virus and pandemic losses. At least that was what they were trying to do. So it may block your recovery of business interruption claims related to COVID-19. Next slide. However, with a catastrophe often comes creativity from lawyers on both sides of the aisle, and the COVID-19 event is no exception. John Hotaling filed one of the initial lawsuits here in New Orleans for Cajun Conti LLC against Lloyd's Underwriters for a restaurant in the French Quarter. And he developed a novel theory that said that the virus was contaminating surfaces for days or weeks everywhere in the restaurant, and that created a physical loss. And he also made an argument under civil authority for a physical loss. And a similar suit, just like this one, was filed thereafter in California for a quite famous restaurant called the French Laundry. So this is a creative effort to see if there can be a business interruption claim based on the coronavirus loss. And some of the creativity is coming out of New Orleans. Lawsuits like this one face an uphill battle because of the interpretations of physical loss I just discussed. What's the takeaway? You should read your policy, you should talk to your agent, and you should assess whether you want to participate. Next slide, please. There might be some other coverages that come up from the COVID-19 event. The CGL coverage could be implicated if there's negligence in failing to disclose and exercise reasonable care regarding exposure. The D&O coverage sometimes comes up where shareholders have not been properly briefed on events. Look at the cruise lines. Next slide. The E&O coverage can be implicated when there's improper public exposure to a pandemic. The work comp is catching COVID-19 on the job, a work comp injury. There may be some discussion of that. Next slide, please. So Boris is one of the most famous of the people who have caught COVID-19. Don't be like he is and get swept away in the flood of events after the COVID-19 pandemic. Prepare and hopefully take a few things away helpful from what we've talked about. Next slide, please. Next slide, please. And then the next slide, please. And finally, Ellis and I will talk about a few questions that we've received when this presentation was first brought up, and then we'll take any additional questions from the audience. Ellis?
Would you go back to the last slide on known audience topics, please? All right, so before we get into this, I have to apologize. I got a little note. Mr. Johnson is now out of intensive care. He's lucky he wasn't swept away. So these are some questions that Ted and I were told y'all had some interest in. You may have some others, but real quickly on one, any insurance policies issues dealing with working while at home? Well, actually, there's a fairly important one for those of you that have a group health policy for your employees. The general rule is it covers full-time employees that work more than 30 hours a week. FYI. The issue that Ted was talking about under comprehensive general liability policies, the issue is relating to the course and scope of their employment, which makes it harder to deal with when they're at home. It's just an issue of proof. On the bullet point on productivity being down, tools used, can you cut hours, rules on managing? The answer is the playbook is open, folks. I can tell you that the Families First Act and the CARES Act don't want you to lay off people, but if you have to, you have to. Can you cut hours? Of course. The only thing you have to deal with in cutting hours will go back to some of the laws we spoke of earlier, like, laws prohibiting discrimination on the basis of age, sex, color, religion, national origin, or disability. Here's a tough one. Let's say you're going to do a partial layoff. I'm not telling you to do it, folks. But let's say you decide to do it. How do you do it? I can tell you the way most companies do it outside of the union context is they want to keep their best workers. I can tell you the way unionized companies do it, and there's a certain, you want to avoid litigation, you want to appear absolutely fair, use seniority. I'm not telling you to do it, but I'm telling you don't ignore the fact that seniority is pretty easy to show. You didn't discriminate on the basis of age, sex, color, religion, national origin. Usually when they started working for you. What could the future ramifications of this pandemic be on the legal and architectural professions? And by the way, just because I give you an answer doesn't mean this is the only answer. Ted may have some thoughts. Y'all may have some thoughts. But I think we're going to go back to the future. And by that I mean wellness programs. Not that I watch the news that much, but I read the news and, they're talking about this pandemic is disproportionately impacting minorities, whether they're African Americans or the poor. The EEOC they have guidance on a wellness program, but they don't like them. They think they can be used to discriminate. They think that somehow life could be unfair because, by the way, there's something called the Genetic Information Non-Discrimination Act, because maybe you're obese because of genetics. I said obese. I was joking. Obese. I think the wellness programs are sort of a back to the future. By the way, attendance is still a essential job function. Last thing we can talk about, then I'll see if Ted or anyone else wants to ask questions. We're going to see the use of technology. Like, that's a real profound statement. Anyone could have seen that coming? Yeah, they could, of course. But the point here is that now before you enter a building, they may take your temperature. You may want to do this as long as you have someone that's qualified to do it. By the way, that's a great way of keeping your workforce safe, of avoiding negligent hiring and retention policies. Now you deal with HIPAA issues and disclosure issues, and it's enough to make one pick up my favorite drink, which is bourbon, but I'm joking. It's not easy. Ted, go ahead.
So as far as the future goes, thank you, Ellis. I've got 3 takeaways, and then we'll open it up to any additional questions. My 3 takeaways are: first, Corona is here to stay, like the flu, like HIV, like West Nile virus. And from now forward, we eventually figure out how we manage it and how technology helps us beat it with a vaccination or other. The second takeaway is that telemedicine becomes the new way we go to the doctor most of the time. And the final takeaway is that good employee health plans become more of a competitive advantage and a disadvantage for small businesses who can't aggregate into a large pool. Thank you with that. And with that, we will see from our hosts if we have any other questions.
We might want to give it a minute, see if anyone types anything in here.
While people think as to whether they have any further questions, let Ellis and I say thank you so much for your attention while we presented on business issues and employment issues with the coronavirus. We hope it's been helpful to some of the decisions you have to make. We at Deutsch Kerrigan deal with these types of issues now on a daily basis, and we look forward to working with you if you have questions. With that, I'll see if there are any questions. And if I hear that there are none, then we'll shut it down at this point. Thank you so much for your attention. Anything further on the host end?
Yeah, we'll just, yes, and thank you both for, for being with us today and for sharing all of your knowledge. We greatly appreciate it, and we are glad to host you virtually.
Thank you very much.
We enjoyed being with you. Y'all have a good day and be safe. Goodbye.
Great. We're going to switch over to our, just kind of close things out with some upcoming learning opportunities that we are going to be hosting, again, virtually on Zoom next week. So on April 15th, we have another webinar with professional affiliate member Daphne Construction. And then after that, we're beginning a series on staying healthy indoors with other professional affiliate members, Tarkett, Benjamin Moore, and Ellie A. So we'll have a whole series of HSW starting the week after next. You can visit aineworleans.org to register for those. And if you want to continue the conversation, please join us on LinkedIn at the New Orleans Members Forum. We have a great many resources available up on our website if you'd like to check those out. And if you have any questions or want to connect with the AI New Orleans staff, just reach out to us by email at aaron@aineworleans.org or lauren@aineworleans.org. And again, thanks everyone for joining us today, and stay safe, and we'll see you soon.